out of all assistance now, confusion in NDC. Amanfo bebree se omonti asese nti a Electoral Commission metre Jane Mensa omuntu Mensa no na nkomo no very interesting to the extent say even some MPP people se omonti asese because secretary to the MPP party metre Justin Kodua eka se onu ntumi defend Jane Mensa because Jane Mensa misconduct ni nyoma bi oye no odwo ho onti asese. Same way in assistance now NDC for an concerning Jane Mensa. Now when it comes to the NDC, Kwesi Pratt in an interview of course was Pan-African TV, Obedin Komo Chichim say on Tiasie because he never kaya few days in no Mampeni Mahama report fini camp by Koko for pray for Koko Manino. Report by some say EC Jane Mensa to Mensa Sano. Ane onrene AG Kisi Jabin omuntu means some na in some the way an able bobano with Kisi Jabin the enpo and sheda problem say EC boss Jane Mensa a man for press a bay on Monsano no man penny ma Amazon to means sano and our bay viral topic and the Obia Kabi now the NTA and someone Kwesi Pratt said I bet to your church him say no one pa say or more castle moon to means sano a yen one because petition or no craning sakabi. The information all kind of petition in muno and yasem ketwa. Now the Indian common. Now mami whose opinion I will comment.
Has been taken yeah.
Matter finish.
Because the process leading up to the decision by the Chief Justice that no prima facie case has been established is lawful. You cannot challenge it on the basis of process or the law. It's finished.
It's finished, yeah.
What you can do now is to test the quality of the decision. But that can be done only for academic purposes and purposes of entertainment and education. But as far as the Constitution is concerned, as far as the law is concerned, the Electoral Commissioner, Chairman of the Electoral Commission and her two deputies cannot be removed. And you cannot appeal against the decision of the Chief Justice. Matter is closed. You understand? And this should apply to all Article 146, processes and decisions. So the Chief Justice has decided you cannot contest him. It's the decision. The law is the law, as they say. But I have had the privilege of reading one of the petitions. And I'm still struggling with myself whether to publish it or not to publish it. And it's a 95-page petition.
Hey.
Thorough. Really thorough. This is the petition which is talking about data breaches and the dangers that the Electoral Commission through its practices subjected citizens to. I mean, very thorough, 95 pages with copious references to practices and documents and so on. And I'm wondering how anybody can decide that a petition like this is frivolous. I just cannot imagine it. One, if you read Article 146 very closely, and I'm happy that Mr. Hussein is here, at this point of the determination of whether or not there's a prima facie case, evidence is not required. This is not the period where you examine evidence or examine facts and so on. This is a period where you look at the matter before you and see whether or not what the petitioner is putting forward touches on the crimes prescribed by the Constitution. You understand? Prima facie case, on the face of the facts presented, without going into the evidence, can we now take the next step forward to look at the issues, look at evidence and so on, and determine guilt or not? So the determination of a prima facie case does not establish guilt or innocence. okay, on the face of the facts available as presented, should we go to the next stage of calling for evidence and looking at the facts? So I am completely shocked. I'm completely shocked by the decision of the Chief Justice. But as it were, that's his decision. And the Constitution empowers him to make a final decision, and he has made a final decision. We have to live with it. The only way in which these matters may be resurrected, and I'm using my words very carefully again, may be resurrected, is if others decide to petition again. Now, if others decide to petition again, will the Chief Justice reasoning leading him to this conclusion change? I don't know. If others petition again, will the petitions come at the time when he is still Chief Justice, or to come at the time when he's on leave, or when he's on retirement? I don't know. But all these are imponderables, as they say. You understand? So, yes, others can petition, but there's no provision for review.
Right.
No provision for review by the Chief Justice himself, or even by the bench. So, matter is closed until fresh petitions come up. So, this is where we are. What can we do? You see, this is the thing about democracy, or bourgeois democracy. Only one person out of a population of 35 million is clothed with the authority of deciding whether or not this case should go forward or not. One person. And you cannot appeal against his decision. You can't do anything. Is this democracy? But that's another matter for another time. But that is what the Constitution prescribes. That when it comes to removal of electoral commissioner or judges of the superior courts and so on, only one person, one person. He may be taking the decision at the time when he has malaria. He may be taking the decision at the time when something has contributed to some imbalance in his system and so on. But his decision is final. That's what the Constitution says. And we all, 35 million people, have to abide by that decision. We have to abide by the decision, whether we like it or not. That is what the law says. Finish.
Mr. Land, would you therefore, going forward, the Constitutional Review Committee, they've submitted their report. Maybe perhaps should we look at what Mr. Pratt is talking about? A need to review certain aspects, the removal of certain,
At all times, this bourgeois, limited bourgeois democratic order, at all times, we will have situations such as this one. It's unavoidable. You can't have a situation where every issue is subjected to a national referendum.
Exactly.
So there are many times when one single individual is going to decide for all of us, and we have to live with it.
Yes. We are now Mr. Hussein, former member of parliament for Tamale Central, so Panos. Hey, no constitutional law is quite confused by the Chief Justice. I know who be that, TB.
So, this one is not anybody's personal idiosyncratic view about what should be contained in the petition. It's the Constitution that provides guidance. And so, the Constitution, Article 146(1) provides what should go into a petition to remove the Justice of the Superior Court of Judicature or the Chief Justice. And the Chief Justice is the Justice of the Superior Court of Judicature. So, from the High Court, Court of Appeal, the Supreme Court. Now, it must be on stated misbehavior or incompetence or inability to perform a function because of infirmity of body or mind. And so it's clear. Now, even with the inability to perform because of infirmity of body or mind, if it is a mind, you have to establish a committee of medical team to know whether his mind is still working or not working. And so that's a different matter. But stated misbehavior. So I'll give you an example. The justices of the Superior Court of Judicature and all justices are supposed to be neutral, non-partisan. So if you, in your village, you chance to see a justice of a superior court of judicature mounting a political platform to campaign for a political party, that's stated misbehavior. Stated. You don't need any other thing. You can remove that justice from the bench on that basis because it's stated misbehavior. Incompetence. He writes a ruling, and when you read the ruling, it doesn't follow any legal or judicial precedent. There are no legal principles or precepts. I mean, so you question his competence as a judge, incompetence as a judge. Now, so when it comes to electoral commission, why are we talking about? So the commissioner, electoral commissioner, enjoys the conditions of service of a court of appeal. So her removal process must be equal or similar to the removal process of a justice of the court of appeal. So when we talk of incompetence of the electoral commission, it's not incompetence in terms of judgment, but incompetence in the performance of her functions. Okay, or stated misbehavior. So this is what I mean. If you have reasons to believe that the EC commissioner or her deputies have done something that clearly is a stated misbehavior, you put it in a petition and send it to the president. Or you think that she has been so incompetent that incompetence is not to be tolerated or accepted of a body like the electoral commission. You put it in a petition and send it to the president. So that's it. So the constitution gives us guidance. Okay. Now, and this is the first time you have about 10 petitions being sent for the removal of the EC commissioner. It's the first time. I mean, so it's huge. So it means that there's a general perception of people that the electoral commissioner and her deputies engage in some form of misbehavior, stated misbehavior or incompetence, and so they wanted them out. And it's a right vested in any Ghanaian to petition for the removal of the EC commissioner and her deputies or the special prosecutor. It's a right. Now, so when the people sent and I agree, I'm shocked at the decision because when you look at the decision of Justice Bafo-Bonner against earlier decisions, you find it difficult to rationalize his decision. And let's give you one example. The Constitution again gives the EC the power to create constituencies. But in the creation of the constituencies, there are certain procedures to be followed. The constituency must be created before the next election. Because if the constituency is created now, the people they cannot be represented. Okay? So when you create a constituency after the holding of elections, for the full 4 years, the people cannot be in parliament because you cannot, we did that to prevent gerrymandering, and bastardization of the electoral system. And so if not, the government could create more constituencies in the MPP areas to further decimate MPP if we allow that. So the whole rationale is to lock it in and make it impossible to determine the outcome of an election when a sitting parliament is there, and also not to change the composition of that parliament. So in 2020, EC created constituencies. Created who? Hohoi. Okay, and in the creation of Hohoi, it left 4 communities. 4 communities. Sal, Apafu, Lulubi, and Lipe. Left them. Now, I was in Parliament. The EC Electoral Commissioner came to Parliament. The late MP of Hohoi drew the attention of the EC Commissioner in Parliament that the description of the Hohoi constituency seemed to exclude 4 communities. And if that was not rectified, the 4 communities would not be represented. So it was not something that was not brought to her attention. It was brought to her attention. Now, somehow, for 4 good years, the people of Santrofi and Apafo, Lolobi and Dikwe were not represented in Parliament. Look at what the Chief Justice says. Oh, you don't want me to read the Chief Justice's report? He says, while the allegations raise serious constitutional and administrative questions, they do not on their face meet the threshold required for a prima facie determination of stated misbehavior or incompetence warranting that a committee be set up to inquire into the petition. So Chief Justice says that, well, such constitutional breaches or administrative breaches are so serious. Okay, but that on the face of it. So that's where I disagree. Do you need intentionality? You need to prove intentions when you are breaching the Constitution. You need to prove the fact that a constitutional provision that has been breached. That's all. And whatever motivated move that person to breach the Constitution.
Not really.
In that of was a uti nkomo na Kwesi Pratt eba be di na me my first video me kan me see that thing there as it stands now. It either say NDC 4 ebe ye kululu no me jai EC boss Jane Mensah. The moment on be yes as on kai so position on beko. Because information on makafa Jane Mensah hui pa still na no man a chance no. The moment they do that to position on beko. And apart from the opposition on grants and some no, see Jane Mensah and Kasayen Shedan who need ni role play under the Akufo-Addo government or yen who or MPP ni or MPP ni. Inti sisi ano be no or NDC ni or NDC ni ana. And I dey no crowd to change so MPP ni ana so NDC ni. Yen nim say Jane Mensah Akufo-Addo buy no dey ni BBC so. But Jane Mensah were a lot of flaws. I think say the NDC shouldn't overlook it. About saying na utumi bobo end of elections we na 9 constituencies utumi nchire nipo win here. All these things are something be the NDC is ready to continue with this and then opposition in the ombekopa. Maybe the only way ye care. But along the line another petition we bob the be in dia. But for the meantime, we need their Mensaka and the Kwesi Pratt James say eye no one wapa. Also I will share video no one say. Edin Ghana gossips. Yet more updates. More gist. Eba wakwe.